This is just part 2 of setting up the articles of incorporation. I'm posting a second video so that I can dedicate it to strictly just the bylaws and just to make sure that everything does comply. Which showing here starting with Article 1, Corporate Authority, which we do have the Cutting Edge Computer Repair Inc. And we have the name here. As per the first video, we did show that was actually complies, and that's 48-12-103 of the Tennessee Code, Title 48. So that did comply, and that was actually successful. So the name and everything, we have that taken care of. As far as the officers and registered agent, we have listed Bradley Stevens Harris and his address 1753 Oakland Drive, Memphis, Tennessee 38103. As far as the registered agent complying, that one is actually under Title 48-15-101, and that's the registered agent. And to show that it complies, shows each corporation must continuously maintain in this state a registered office that may be the same as any places of business, and a registered agent who may be an individual who resides in the state and whose business office is identical. And didn't want to read everything there, but it looks like that does comply. So we'll go ahead and go back. And now for Article 3, that one is dealing with meetings of shareholders. I'll scroll up a bit for you. And that's actually under Title 48-17 for shareholders. So I'll go to that one in meetings. That's part 1. And just the different sections here. Place of meetings, I did not see that here. So I don't know if that's something that matters as far as where it should be held. That may be something that has to be agreed upon, amongst the shareholders possibly, but I did not see that on the code here. I do have annual meetings. Each year the corporation shall hold an annual meeting of the shareholders on such date. So with that, I do have here, unless directors are elected by written consent in lieu of an annual meeting as permitted by 48-17-104, corporation shall hold a meeting of shareholders annually. So it looks like that does comply. So we can actually go to the next one. Section 3, special meetings, and that one is actually on this list, 48-17-102. Which it shows here for special meetings of the shareholders for any purpose or purposes may be called at any time by the president of the corporation or board of directors or shareholders holding at least 10% of the issued and outstanding voting stock of the corporation. So here, corporation shall hold a special meeting of shareholders on call of its board of directors or person or persons authorized to do so by the charter or bylaws, or unless the charter otherwise provides the shareholders of at least 10% of the votes entitled to be cast on any issue proposed. So with that pretty much in a nutshell, that one is actually complying. So we can go back. And the next section is notice of meetings, which we do have that, Title 48-17-105. For this one, shows whenever shareholders are required to permitted to take, and that's a typo there, to take any action at a meeting, a written notice of the meeting shall be provided to each shareholder of record entitled to vote, or entitled to notice of the meeting. So let's see if that one actually complies. All right, and we're just kind of skimming through here. Okay. And in case of a special meeting, I do see that notice of a special meeting must include description of the purpose. So that particular portion I see that does comply. And let me go back up here. Whenever shareholders are required to and permitted to take action at a meeting, a written notice of the meeting shall be provided. And let's see here. So I don't show here anything indicating a written notice. I'm sorry. So far, I show that 48-17-105C. Excuse me. Looks like that actually is the item that complies. I didn't see the remainder. I'm sorry about that. Let's go back. And we're going to look at the quorum at meetings for section 5. And let's see here. Didn't really see anything for the quorum. I think that was one that was actually kind of searching for. But I did not see it here. Let me go back. Maybe I'm skipping something. Just want to make sure I didn't. No, I didn't see that one. I didn't see proxy. Voting, I did see that. Let me move forward here. Voting at meetings, if a quorum exists, action on a matter other than the election of directors is approved if the votes cast favoring the action exceed the votes cast opposing the action. So let's check that one out. And oh, here we go, quorum. So we found proxies. So good. I'm sorry. So we can actually go back up and we can look at the one for quorum. So I'll click on that one. All right, so just to redirect here, shareholders may take action on a matter at a meeting only if quorum exists with respect to that matter, except as otherwise provided by law. A majority of the outstanding shares of the corporation entitled to vote, represented in person or by proxy, shall constitute a quorum at a meeting of shareholders. So let's see here, and looks like and looks like that does comply. All right. Wording is just a little different, but it does comply. So now we have proxies. And for proxies, let's see here. We have each shareholder entitled to vote at a meeting of shareholders or to express consent or dissent to corporate action in writing without a meeting may authorize another person or persons to vote for him or her by proxy. And let's see here. And shareholder may vote such shareholder shares in by personal proxy without limiting the manner in which the shareholder may authorize another person or persons to act for a shareholder as proxy pursuant to this section. So yes, that actually does that complies. So we have the proxy. So now we're going to go back to voting at meetings, and let me go here. Alright, so for the voting at meetings, let's see here. If quorum exists, approve of votes cast favoring the action exceed the votes casting. Okay, and the votes cast opposing the action. So let's see here. Alright. Directors shall be elected by plurality of the votes cast by the shares entitled to vote in the election. Let's see here. I don't see that. Let's see here. I was going to see if I see like any similar wording. But this is more so about shares. Nothing about what that one says. Let me go back here just in case I missed something. Maybe I'm clicking on the wrong thing. Let me go back. No, that's the same one. Let's see, voting trust. Let's try that. That's more about trust. So that one I am not actually locating. Let's see, let's try part 4. No. So it looks like that one we did not locate. Let's see, maybe a list of shareholders. We can go back. Action by single or multiple voting groups. Let's try that one. Still, the wording's a little iffy, so I'm not going to utilize that one. So I'll go ahead and go back to the list, shareholders list. So let's see here. All right, the officer of the corporation who has charge of the stock ledger of the corporation shall prepare and make at least 10 days before any meeting of shareholders. So let me see if that wording is kind of jumping out here. Sometimes the word will jump out, and then we can read the rest if we need to. Now this is discussing meetings, shareholders list for meetings after fixed record date for a meeting. A corporation shall prepare an alphabetical list of names. Let's just see. Yeah, I'm having a little trouble with that one as well. Yeah, I don't see any similar wording that may be with that one, so I don't want to guess at it, so I'm not going to guess. But let's see. Let's try consent in lieu of meetings. Let's go back to meetings. An action required to be taken or which may be taken at any meeting of shareholders, whether annual or special, may be taken without a meeting, whether prior notice and without a vote. If a consent in writing setting forth the action so taken shall be signed by the holders of outstanding shares having not less than the minimum number of votes that would be necessary to take such action at a meeting at which all shareholders entitled to vote were present and voted. Let me go back to the special meeting and see if that may have been one of the no, I thought I may have seen something there that may have been pertaining to that, but I don't see that either. No, so it looks like I'm not having a little trouble with that one too. Let's see, conference call. One or more shareholders may participate in a meeting of shareholders by means of conference, telephone, video conferencing. And let's see here. Yeah, I didn't see, let's see, notice of meeting, just in case. Just want to kind of look at it. Contact with the meeting, maybe. Yeah, kind of having a little trouble with that one as well. The wording is a little bit different than what I'm showing here. Also didn't see anything as far as the annual statement. So we'll have to do a little bit more research for that one as well. Now we can go ahead and skip down to Article 4, Directors. And that one's actually powers of the director. So that one's actually 48-18. So we'll go down to the chapter 18 here. The directors, let's try board of directors. I'll go ahead and go to this one first since I'm already here. Numbered election of directors. To see if that section qualifies. And this is number, which you've already given us 2. And the number of directors, each director shall be at least 18 years of age. The directors need not be residents of the state of incorporation. So here, board of directors must consist of 1 or more, which we have 2. The charter of bylaws may provide the board of directors has power to fix or change the number of directors. So let's see here. Shareholders annual meeting. Okay. So it looks like it complies with A. So 48-18-103A is what I'm showing here. As far as the election, each director shall be elected for a term of, since I didn't have that information, I just put 7, just a ballpark, but we can always change that. But I wasn't for certain there since I didn't see that on the initial client list. But like I said, we can change that if we need to. But let's see here as far as the election. Okay, directors are elected at the first annual shareholders meeting and at each annual meeting thereafter. So I don't show any sort of fixed number here. Looks like it says the charter or bylaws may establish a variable range for the size of the board of directors by fixing a minimum and maximum number of directors. If a variable range is established, the number of directors may be fixed or changed from time to time. Yeah, so the ballpark, I just put 7. So it can be, according to this, it complies, and it can be at whatever time you all designate. Let's see here. This is one requirement. Nomination of directors. Let me go back here. I didn't see nomination. Shall nominate candidates for election. Okay, I think that may have been on the same thing. Let me go back. Election of directors. Let's see. Nomination of directors. The board of directors shall nominate candidates to stand for election as directors, and other candidates may also be nominated by any shareholder of the corporation, provided such nomination is subject in writing to the corporation secretary no later than 30 days prior to the meeting of shareholders at which such directors are to be elected. But let's see here. Yeah, let's see. It just doesn't have this 30 days, doesn't have that wording. But the board of directors shall nominate candidates to stand for election as directors, and other candidates may also be nominated by any shareholder. So let's see here. If the charter authorizes dividing the shares into classes or series, the charter may also authorize the election of all or a specific number of directors by holders of one or more authorized classes. That's a little iffy. Yeah, that one was a little iffy. Those are just staggered terms. Yeah, still not seeing. I had a little trouble with that one. I thought I can maybe go back and try to find it, but let's see. Yeah. Didn't see that one. Let's try vacancy. Which have vacancies on board. Alright, except as otherwise provided by law, any vacancy in the board of directors occurring by reason of an increase in the authorized number of directors or by reason of the death, withdrawal, removal, disqualification, inability to act, and or resignation of a director shall be filed by the majority of directors then in office. So here, the shareholders may fill the vacancy The board of directors may fill the vacancy unless the charter provides otherwise. If a vacancy occurs on the board of directors, including a vacancy resulting from an increase in the number of directors or a vacancy resulting from a removal, with or without cause. Yeah, that actually, yeah. So that one complies. So we're good with that. All right, the successor shall serve the unexpired portion of the term of his or her predecessor. Any director may resign at any time by giving written notice to the Board of Secretary. So let me go back with that because that's a vacancy. But I also want to do resignation of directors since that particular phrase is there. A director may resign at any time by delivering written resignation to the board of directors or its chair or to the secretary of the corporation, which means that complies. That actually complies with two codes, so that's good. So we'll go ahead and go to the next section, which is again for meetings. At which I think we kind of already did this. So I don't want to be at the risk of being redundant. Let me kind of scroll. And yeah, removal of directors. Any director or the entire board of directors may be removed with or without cause, which we actually just kind of read that. So it looks like that complies. So that's fine. All right, so now we're going to Article 5 for officers, which is actually Title 48-18. So let me go back here. And officers, I think I was already there, sorry. And excuse me, let's see here. As far as positions, the officer of the corporation shall be the chairperson, the president, and secretary, treasurer, and such other officers as the board may from time to time appoint, including one or more vice presidents and such other offices as it deems advisable. So let's see here. For position, let's say maybe duties. That's what that may fall under. And this is kind of given like a generalization, so we're going to back out of that one. I had a little trouble with this one since it didn't really specify, but I think required officers. It didn't have everything, but it should have like, let's see. Just a little trouble on this one as well, as far as positions. We'll say, well, the conduct, that's just really, so nothing that I truly found on that one. Some of these I was not successful, but let's see here. Chairperson, president, secretary. Let's try it again. Yeah. Nothing really specific that I found. Sure, limitations on action since we have like terms of office. No, that's a little different. So it wouldn't be that one. Yeah, it's just redirects. So, yeah, didn't really find that one. Let's try Article 6, 48-16 for capital stock, shares, and certificates. Now, this one I did have a little trouble with as well. However, I saw here, um, I just saw something there. I saw form and content of certificate, and then I saw shares without certificates. So it didn't actually say stock certificates, but the shares of the corporation shall be represented by certificates provided by the board of directors. May that the board of directors may provide by resolution that some or all of any or all classes or series of the stock of the corporation shall be uncertified, certificated. I can't get my words out. I'm sorry. Shares, notwithstanding the adoption of such a resolution by the board of directors. So let's just see, because I need to adjust my glasses. But let's take a look here. And see, yeah, again, this didn't say specifics. Let's look here. Any or all signatures may be by facsimile. So let's see. I want to check something. I thought I saw something. Issuance of shares. Let me just go back here. No. Yeah, little trouble with this one as well because it didn't actually specify the information or anything that was close to it. I saw shares without certificates, thinking that maybe the lost certificates or transfers may be there. But that's not really, that's more of giving like an authorization for shares without certificates. I didn't really specify. Let's see restrictions on transfers. Yeah, just a little trouble with that one. See distributions maybe. Yeah, not really. So we're gonna go to 7, Article 7, which is about dividends and reserves. And I think I saw that, so I'll go back. Excuse me. Alright, so that one, 567. It's actually 48-16, and I think that's the -2. Yeah. Share dividends. Yeah. So let's try this one out since we kind of did a hit and miss with the others. The board of directors may declare and pay dividends upon the outstanding shares of the corporation from time to time and to such extent as the board deems advisable, in the manner and upon the terms and conditions provided by law and the articles of the corporation of the corporation. So let's see here. Okay, so the charter so authorized the majority of the votes entitled to be cast by the class or series to be issued approves the issue. There are no outstanding shares of the class or series to be issued. The board of directors does not fix the record date for determining shareholders entitled to share dividend. It is the date the board of directors authorizes the share dividend. Unless the charter provides otherwise, shares may be issued pro rata and without consideration to the corporation's shareholders or to the shareholders of one or more classes or series. An issuance of shares under this subsection A is a share dividend. So let's see here. It's just some of the wording. Yeah, it actually, because board deems advisable in a manner specified upon the terms. So the wording that, it's just different wording, but yeah, that complies. I didn't see anything for section 2 for reserves set apart out the funds of the corporation available for dividends. Said some as the directors form from time to time in their absolute discretion. Yeah. I may be wrong. Let's see here. All right. The board of directors may abolish such reserve and the manner it was created. Yeah, that actually complies because it kind of says what this is. If the board of directors has not fixed the record date for determining shareholders entitled to a share dividend, it is the date the board of directors authorizes the share dividend. So, I'm gonna say that. Yeah, that complies. That's fine. All right, and now we're down. We're almost done. So now we're on 8. Are we on the last one? Let me just look. And we are on the last one. I'm sorry. So Article 8, General Provisions. This is Title 48-18. So let me go back here. All right, and this is Chapter 5, actually. Or Part 5, sorry. And to be exact, it's 508 insurance. So this actually was the easiest one, I guess, because this one says exactly word for word, which is what I like instead of having to hunt. So, but sometimes I have to hunt. But this one, the corporation may purchase and maintain insurance in a reasonable amount on behalf of any person who is or was a director, officer, agent, employee. So this one actually says it word for word. So this one complies. So that's the easiest one on the page, I would assume. Let's see, corporate records. I did not see one for that section. Let's go here. Identification. Yeah, I didn't see one for that. That was a little difficult as well. Let me just go to general provisions. No, I didn't think so. I looked in that one earlier, and that one didn't quite say, because I didn't see as far as the notice or the waiver of notice. So though some of these I wasn't successful in locating. Just wanted to make sure I wasn't overlooking anything with this as far as finding the information that we're looking for. Yeah, everything's kind of here. Let's see distributions. No, I think we looked at that, and that one wasn't quite it. But yeah, as far as the fiscal year, the seal, yeah, I was having a little trouble, so I was trying to see if maybe it'll jump out, but still. Yeah, still not jumping out here, so but yeah, I'm gonna need a little help, so if you can just let me know. But other than that, I would say the vast majority actually complies, with the exception of the one that only a portion of that actually complied. I just wanted to go back to it here. And it could just very well be because I didn't quite find everything, so I don't want to say that it doesn't or that it does, but anywho, just without having to go over everything, and then the very last page is just the signatures. It'll be easier to do it this way. That way I'm not scrolling. So, but it's just the signature page. So once we get everything finalized, then we'll go ahead and get the signatures done. And again, the first, this is part 2 of the setting up of the articles of incorporation. So if you have any questions, just give me a call. Thank you.